Friends, gives me great pleasure to come back to you after a gap of about more than a year. I intend to start this second leg of our journey on legal education for a common man with some concepts in legal languages which a common man may not know, but it means something when the lawyers or judges use them in the court of law. So let's start now. What is law? It's not easy to give a very concise definition. However, a simple definition of Salmon says, law consists of rules recognized and acted upon in the court of justice. Austin says, law is the command of sovereign. Now, what are the sources of law? There are formal source and the material resource. In material sources, they are further divided into legal and historical, and legal resources are further divided into legislation, precedent, customs, and professional opinion. Now, what is international law? International law is of two types. One is public international law. So, these are the rules acknowledged by a general body of civilized independent states to be binding upon them in their mutual relations. And private international law deals with cases of individuals when foreign element is involved. What is justice? Justice is moral or legal fairness. So it is of two types. One is natural justice or moral justice, and second is positive justice or legal justice. Natural justice is meted out by act of God, whereas positive justice is as administered by man. What are rights? This is of fundamental significance. Right is an interest which is recognized and protected by law. So, a party has a right when others are bound or obliged by law to do or forbear from doing something towards or in regards to him. Thus, a right is an interest vested or created under a law or a contract. Now, what are the kinds of rights? There are 6 types. 1. Rights over material things, that is house, car, books, etc. Second is rights over immaterial or intangible property. For example, copyright, patents, trademarks, goodwill, etc. Then third is rights in respect of one's own property. For example, it is not to be assaulted or imprisoned falsely. Rights in respect of reputation. For example, right not to be defamed. Fifth is right in respect of domestic relations. For example, husband's rights against his wife, or person's right against his parents, and parents' right against their child, etc. Master's right is also covered in this over his servant. Rights in respect of others' rights, that is, whenever you enter into a contract with someone else, you have certain rights against that person. What is, suppose it is a sale, then what is sold to him, you owe certain rights against that person. Now, various kinds of rights are as given next, although I don't intend to go into the details of everything. First is legal and moral rights. Second is perfect and imperfect right. Third is proprietary and personal right. Fourth is inheritable or uninheritable right. Fifth is primary and sanctioning right. Sixth is principal and accessory right. Seventh is positive and negative rights. Legal and equitable rights. Real and personal rights. 10th one is rights in rem and rights in personam. 11th is rights in re propria and rights in re aliena. 12th is last, servient and dominant rights. In this, rights in rem is which is available to a person against the whole world. That is, for example, not to be defamed. Right in personam is against a particular person only, that is in a contract of sale. Suppose property is between A and B, sale transaction, then there are rights against the other person, only against that person, and no third party can sue in the court of law. Now, what is remedy? It is the legal solution to an infringed rights. That means the rights must get infringed, and whatever solution is provided, man-made solution, is legal right, is the remedy. If a man has a right, he must have a means to vindicate and maintain it. Thus, whenever there is an infringement of right, the solution provided by law is remedy. It is said that every injury must have a remedy. What is duty? Duty is an obligatory act, opposite to which is wrong. And therefore, there can be no duty unless there is some other person to whom it is due. Thus, duties is in strict them do have corresponding rights. So every duty has a corresponding right. Now, what is wrong? Wrong is an act contrary to the rules of right and justice. This again could be moral or natural wrong and legal wrong. A legal wrong is an act which is authoritatively determined to be wrong by a rule of law. It is synonymous with injury, that is, a violation of a legal right. A mere loss done without violation of legal right or injuria does not give rise to a cause of action. So, if there is no injury, but if it is only a monetary kind of a loss, then there cannot be any remedy. In the eyes of law, wrongs are of two types: civil wrong, also referred to as torts, and criminal wrongs, which are called crimes or offenses. When civil wrong is committed, a suit is filed in civil court and judge may award compensation if plaintiff proves civil wrong. Whenever there is a criminal wrong committed, a complaint is filed in a criminal court and the magistrate may sentence accused to simple or rigorous imprisonment if the complaint proves the offense. Please note the various terminologies that are used in civil wrong and the criminal wrong. Every wrong inflicts damage. Legal damage is neither identical with actual damage nor does it necessarily mean any pecuniary loss. Every invasion of a person's legal right results in a legal damage and it will have a legal remedy. The principle underlying the maxim ubi jus ibi remedium applies here, and we shall discuss the same principle in coming episodes. Person is any being whom the law regards as capable of having rights and duties. Thus, under IPC, Indian Penal Code, the word person includes any company or association on or body of persons, whether incorporated or not. Thus, persons are of two types. One is natural person, which is a human being. Second is legal person, to anyone whom the law attributes personality by way of legal fiction. For example, corporations, institutions, charitable trusts, etc. Please note here, an animal is not a person because it doesn't have any legal rights or duties. So it is not regarded as a person by Indian Penal Code. Friends, we stop here for today and continue with some more concepts in the next episode. Thank you. For any queries, please address to Adv SDBapat@gmail.com. Thank you.